Welcome to this employer compliance webinar on managing independent contractors, presented by Employer Pro, empowering employers through effective people solutions. My name is Kent Duffy, employment law specialist and director here at Employer Pro. Employer Pro at a glance. Employer Pro protects employers via effective people solutions. We offer a cost-effective membership model with optional benefits, a suite of legally compliant employment documentation, from guidelines, webinars, walkthroughs, and templates for managing key employment processes. We offer employer support, assistance, and representation. We assist employers to navigate workplace compliance and employment laws. Overview. In terms of this webinar about managing independent contractors, we'll be looking at understanding independent contractor arrangements at a basic level, what you need to know, how they work, these sorts of things. Contractor versus employee disputes, where things go wrong, what do you need to know, the potential implications and risks if you're a business or a principal, even an employer engaging or who engages independent contractors. Steps to take as a business when you're engaging independent contractors to reduce legal risk exposure. What are the key legal considerations and risks that apply in this area to watch out for? Employer Pro's resources for managing independent contractors and the tools and various things we have available to support our members with this particular area of employment law and workplace relations, along with practical hints and tips. Understanding independent contractor arrangements. Independent contractors are not covered by most minimum employment protections or standards. So things like annual leave, holiday pay, paid sick leave, public holidays. These entitlements only apply to employees, which has a particular or a specific legal definition. If you're covered as an employee by the Employment Relations Act, then associated minimum employment standards and entitlements apply. If you're a contractor, the same cannot be said. Those basic minimum entitlements do not apply. So independent contractor arrangements or agreements are based on a commercial relationship at its core, not an employment relationship. So that's the point to make really clear. It's a business-to-business arrangement, essentially. So a contractor must be a person or an entity operating in business on their own account, having regard to their skill or services, what they do, the work that they perform, these sorts of things. A key consideration in this context, if you're a business engaging a contractor, is that you must not use an independent contractor arrangement to circumvent employment law obligations. For example, saying that the relationship is a contractor relationship when in reality it is an employment relationship. And I'll speak to the various factors that apply to looking at that particular issue, that is whether somebody is a contractor or they're an employee, later in the presentation. Check out Employer Pro's ebook on managing independent contractors for more information. There is comprehensive guidelines and commentary in that resource, along with practical tools and resources to manage this area as best as possible. Understanding independent contractor arrangements. So we start with the distinction between an independent contractor and an employee. So an independent contractor is somebody who runs their own business. They're in business on their own account. They invoice for their services or the work that they perform. There's no wages or salary structure like in the case of an employee. They pay their own taxes, their own ACC levies, and just if they're registered, GST. They provide their own tools and equipment. They choose when and how they work. They have a lot, or should have, a lot more control and flexibility over how work is performed. Like I mentioned before, there is no entitlement to paid leave like in the Holidays Act or related employment legislation, such as annual leave, sick leave, parental leave, these sorts of things. And they can work for, or should be able to work for, multiple clients. They should be autonomous, and often they're highly skilled and they have more bargaining power because of that. In contrast, an employee, they work under the terms of an employment agreement. They're generally paid wages or salary, have PAYE tax deducted. The employer covers the ACC levies that attach to being an employee to cover things like work-related injuries. The employer provides the tools and equipment. The employer controls the hours, duties, and work methods. So, the employee has to devote all of their agreed working hours to the employer's best interests, these sorts of things. They're entitled to leave in accordance with employment legislation, currently the Holidays Act 2003, and other employment rights. And generally they only work for one employer in most circumstances, but occasionally, people have secondary employment too. Weekend jobs, secondary jobs, night jobs, these sorts of things. But the key distinction there is that a contractor at its core should be or needs to be somebody who's truly and genuinely in business on their own account, whereas the employee is under the control and significant direction by the employer. Contractor versus employee dispute. So something to watch out for if you're a business or you're an employer that engages independent contractors is that when things go wrong or go south, contractor relationships can be challenged via status challenges. And what that means is where somebody's engaged as a contractor and there's a dispute, and what often happens there is there's a breakdown in the relationship and the agreement is terminated for whatever reason. There's no formal process as or like an employment process if it's an employee to manage whatever the issues are that's legally required. Instead, the contractor's let go or they're given their contractual notice period, and it's as simple as that. From that point, if the person believes they have a case, they can raise a status challenge to the Employment Relations Authority or the Employment Court, who will then proceed, if it gets that far, to look at the real nature of the relationship. So the courts or the employment institutions apply a series of legal tests to this question, or to determining the issue of an employee versus a contractor. So that involves considerations of the level of control, the level of integration and independence by the person, the fundamental reality of the relationship. So at its core, it boils down to, is the person genuinely in business on their own account or not? Is this really a relationship that is one of employment, all things considered? If the relationship is really one of employment, then there is a clear risk of misclassification. And despite mislabeling a worker as a contractor, they can be found or be held to be an employee. And so where that applies, there can be a range of legal implications that attach to it. Successful personal grievance claims and associated remedies, things like humiliation compensation, lost wages, etc. Failure to pay or arrears claims for breaches of minimum employment entitlements or standards, things like holiday pay, public holidays, etc., etc. So there are several legal tests that get applied: the intention, control, integration, and economic reality fundamental tests. And all of these tests are canvassed or explained in the ebook, which you can refer to if you want more information, including a checklist for sort of getting a better gauge on where the person may sit if you're engaging a contractor. On balance, are they more of an employee? Is the relationship more of an employment relationship, or is it genuinely a commercial agreement and we can proceed relatively safely on the basis of an independent contractor's agreement? So misclassifying an employee as a contractor, like I mentioned before, can involve significant legal and financial risks. And that's really the key consideration that if you're a business engaging a contractor, that you need to keep front of mind and be very wary of. Steps to reduce legal risk. As a starting point, always use a robust, written, independent contractor's agreement. Ensure that it's signed by both parties and that the person or worker who's signing it understands what it means for the parties to proceed on the basis that the relationship is an independent contractor's agreement. Conduct a level of due diligence or good due diligence, and this includes checking the relationship against the various legal considerations, ensuring how the worker works is consistent with a contractor or independent contractor's arrangement. Like I mentioned earlier, we have an employer resource pack or toolkit on this area that provides a range of useful information, including practical guidelines, commentary, a checklist for navigating this particular issue, being due diligence, with a reasonable level of confidence in terms of getting it right. Contractors should be genuinely in business on their own account. They should be able to work for multiple clients, or at least have the autonomy, the capability to do so. They should be able to control how they work. They have their own company, etc. And this is the distinction between a contractor and employee. So at its core, the nature, or the fundamental nature of the relationship, if you're engaging a contractor, it should come with these features. The more restrictions or control you start putting on contractor sort of engagements, the more it looks like to lawyers or advocates, or at least that will form arguments that really the nature of the relationship is one of employment in the event there's a dispute, and then you end up having to deal with a misclassification exercise. So keeping this stuff front of mind, really the contractor needs to be genuinely in business on their own accounts, the short point there. Do not use independent contractor arrangements when the relationship is clearly or really one of employment. So, the common situations there is really, it's sort of a spade is a spade sort of saying as it goes. And, that's where there's a lot of control. There's very limited bargaining power. The worker is heavily integrated into the business, these sorts of things. If you're in that camp, then really it is highly likely, if not guaranteed, if the matter ends up in a dispute, it's going to be strongly arguable that the person is an employee, and that if that arises, then you end up with a range of potential legal risks and implications in terms of the exposure that sort of scenario presents. Key legal considerations. So when looking at engaging an independent contractor, or if you're dealing with a misclassification dispute, always ask yourself, what is the real nature of the relationship on balance? It can be helpful to look at that objectively, applying the various legal tests in terms of employee or the contractor, whether somebody's an employee or a contractor, and the associated distinctions there. So is the person genuinely in business on their own account? Yes or no? If a status challenge is successful, then there can be a range of awards and remedies can be issued on the basis of the worker being an employee. So things like personal grievance claims, arrears claims for failing to pay holidays and employment entitlements correctly, like annual leave, holiday pay, sick leave. I've mentioned those earlier. A helpful case to look at or to be familiar with is the Uber case, which has made its way through the employment institutions, being the Employment Relations Authority, the Employment Court, the Court of Appeal, and more recently it has been heard by the Supreme Court, which is awaiting judgment. In terms of the thread or the litigation history behind those cases, prior to the Supreme Court hearing the matter, it's my understanding that in all of the cases, including the Court of Appeal, that the Uber drivers were successful in their respective status challenges, that they were in fact employees, based on how the institutions and the courts looked at the various legal tests in the circumstances. Legislative change to watch out for, sort of canary down the mine shaft sort of thing on the horizon. There's a proposed gateway test to be a specified contractor, and if that change goes ahead, then it will make it, more specific or particular around the rules for independent contractors. And if you're a specified contractor, my understanding is it'd be a lot more difficult or near impossible to raise these sorts of status challenges, touch wood, but we've yet to see how that ends up playing out, depending on how the draft legislation progresses and whether or not it becomes law. My general understanding at this stage is that it's anticipated that could become law likely sometime in 2026. So really watch this space is the key message there. Key legal risks, I mentioned this before at a high level. So where things go wrong and the status challenge is initiated and is successful, then various implications can arise. So most commonly these are these take the form of arrears claims, so back pay for minimum employment entitlements and standards, potential penalties for non-compliance. So for example, you failed as the person was an employee, say they were employed for a number of years, the business failed to pay the employee minimum employment entitlements, including holiday pay, public holidays, etc. Those have to be calculated and remedied, rectified, and as well as that, because you fail to pay those minimum entitlements at all, there's penalties that apply. These sorts of arguments and claims get kicked around commonly with these type of disputes, and more often than not, in terms of status challenges and matters that lead up to disputes involving misclassifications about contractors and employees, personal grievance claims typically arise. So where somebody is let go under the pretext of a contractor arrangement who's not, or at the time was not considered to be an employee, but subsequently proves that they were in fact an employee, then no process, presumably in most cases, invariably is followed by in terms of the disengagement of that worker, and that can translate to remedies like lost wages, so-called hurt, humiliation, or injury to feelings compensation, legal costs, etc. So it can get very quickly. These legal remedies and claims can get expensive, particularly if you're a small business that lacks the resources to pay the legal tab associated with the bill with these sort of claims. Then you have the management time, stress, dealing with litigation, and often cases are a matter of public record and get reported on by the various news media outlets from time to time. Employer Pro's resources. Employer Pro has a range of resources and tools available to help employers. We have comprehensive ebooks, including step-by-step guidelines and practical employer toolkits. We have an independent contractors agreement template, status checklists, and due diligence tools. Webinars and training videos like what you're listening to now. Employment documentation, Employer Pro employment agreements and workplace policies, and access to further advice via advisory consultations and hands-on support through consultancy arrangements or formal terms of engagement if required. Practical hints and tips. So the starting point is the real nature of the relationship will always override any written agreement between the parties. So keep that front of mind when you're looking at issues associated with this area. Really, they boil down to, when you're talking about status challenge and challenges, legal status challenges and implications, what is the real nature of the relationship? Is this genuinely one that is a independent contractors relationship or a commercial relationship, or is this an employment relationship and the person is in reality an employee? And the pendulum and the associated outcomes will tend to sit on balance wherever that analysis arrives at. So always carefully assess the work and the engagements that you're looking to base an independent contractors agreement on. Coming back to the point, you need to have a reasonable level of confidence following due diligence that the engagement will withstand scrutiny if it's challenged and that person is truly an independent contractor. Ensure how the contractor works is consistent with an independent contractor arrangement. So really this should be minimal control, limited or minimal integration, and limited dependence by the contractor on the business. You won't always be able to get all of these things stacking up in that favour, but the more distance that you can create there, the less independence, the less integration, the less control. These will be helpful in terms of structuring that relationship and ensuring that it is truly and genuinely one that is can be premised on an independent contractor relationship. Ask yourself, is this worker genuinely in business on their own account? Yes or no? Be aware that workers engaged as a contractor can initiate legal status challenges. So if they're successful, this can come with a range of legal implications, including the ones that I talked about earlier, including arrears claims and personal grievance claims, associated remedies, etc. Read Employer Pro's ebook on managing independent contractors. Use the applicable templates, including the independent contractors agreement and the associated checklist for conducting your due diligence. Disclaimers. This webinar is for guidance and information purposes only. It does not constitute formal legal advice. Employer Pro Limited is not responsible for any liability or otherwise arising out of the use of this webinar. Seek professional advice from Employer Pro Limited by becoming a member today if further assistance or support is required. Employer Pro, supporting employers. Visit www.employerpro.co.nz or email info@employerpro.co.nz for further information or assistance.